Hello, my name is Peter Lupo. I am a residential real estate lawyer. Today we're going to talk about New Jersey real estate closing procedures, a primer. So let me run you through this right here. We're going to go over the contract, the attorney review, the deposit, home inspection, the appraisal, title insurance, judgments, payoffs, mortgage commitment, certificate of occupancy, and then the closing itself. And we'll go through each one of these in order. So let's go over to the contract. This is the governing document for the entire transaction. This is what guides everything. And it contains all the key provisions regarding buyer and seller rights and obligations. So I'll have things about the certificate of occupancy, the zoning compliance, risk of loss during the contract prior to closing, some sort of catastrophic loss like fire or flood that happens before it. And it has all the key dates and timelines, the things that people really care about. The deposit due dates usually have multiple deposits. You have your initial and you have your second one. You have a mortgage contingency date. That's the date in which you have your mortgage by. Projected closing date, the date you're actually going to close. And you, in New Jersey, we require with real contracts require a 3-day attorney review contingency. So that's required by state law for both the seller and buyer. Some of the standard contract addendums that attorneys will include is a property sale contingency, typically by the buyer that they have to sell their current home or they can terminate the contract. Usually need the proceeds of that sale in order to buy the next unit. Condominium units, it's a property is a condo unit, then the financial well-being of the condominium regime is considered. It could kill a deal if the condo is in bad shape, or if a membership of the condo association is necessarily costly and difficult. So think of some things that typically come about with condominium units or assessments. Say, for example, a roof, a pool needs to be replaced, an elevator has to be updated, the fascia of the brick has to be upgraded. Those are the types of things that may have unexpected costs for a period of time for the condominium association. Those are the types of things that might be concerns to buyers. Lead-based paint disclosure, one of the standard forms Realtor provides. It's for homes built prior to 1978. And then you have different types of loans, FHA and VA loans. Typically adds a little extra layer of administrative bureaucracy. We deal with the federal government. It's typical. Uh, has special conditions that seller must agree to least agree to, unless they are blindsided as the transaction proceeds. A lot of things that aren't required under conventional loans that FHA and VA loans have. So those types of things to look out for. Some of the additional addendums, solar panels are becoming very, very popular these days. A lot of people want to have help decrease their electrical costs from the traditional power grid, and people are leasing and they often finance solar panels, and you have to transfer them. And sometimes there's difficulty getting in touch with the folks who own the solar panel companies. You have to transfer those rights, and that could be a headache in itself. So keep a lookout for solar panels on homes. Seller concession. They may offer a concession in order to induce the buyer into contract and help reduce closing costs. Those are very common. New construction, you're required to have a new home warranty. And you see the code over here in NJAC 525.1. And then coronavirus. So less of an impact now than it was a year or two ago. But a lot of parties remain cautious and require COVID-19 terms being inserted in the contract, either by a standard coronavirus addendum or via an attorney review provision. Some of the other things in the attorney review to look out for. Um, make sure you understand that it is agreed upon by both parties once the contract is signed. So you have a 72-hour time frame when it's fully executed by both parties. During attorney review, agreed upon changes can be made to the contract. So you might want to scrub through it. And, for example, what you might look over there and talk to your client, see things that were included, excluded. Maybe a chandelier, for example, that's specifically excluded. You might want to talk to your client, make sure that was in fact agreed to, and you can make any changes to the actual attorney review form of any kind of nature, including items to be removed and items that stay. So either party can walk away without any penalty to the other. They don't need an explanation during that 3-day or 72-hour time frame. Either party could just cancel for no reason at all. As you see over here, last bullet point over here, the attorney review could be just because the sky is blue. No reason is required to give to the other party as to why you cancel during the attorney review contract. Just bear in mind that when you move forward after the attorney review is out, you need to have a contractual reason under that contract that I mentioned earlier to cancel.